hot off the presses. This week in San Antonio, the family law section of the state bar released a huge survey of all the judges in Texas that hear divorce cases. And you might be wondering, how likely is a judge to order 50-50? How much do they care what that parent evaluator, child custody evaluator really has to say anyway? Are they going to follow guideline child support? Or are they going to enter an agreement that the parties have reached? We've got answers to all those questions and more.
Ruby Bolton is the founding attorney for the Bolton Law Firm, one of the largest law firms specializing in divorce located in Montgomery County, Texas, including a practice in Harris County. Ruby Bolton is board certified as a family law specialist by the Texas Board of Legal Specialization. Ruby is a super lawyer designated by Thomson Reuters. Ruby is one of the best, designated by the Houston Chronicle, and she would love to share everything she's learned in the last 30 years with you.
Hi, welcome to Divorce Decoded with Bolton Law, where we delve into what can go wrong in a divorce and what you can do to make it go right. So I just came from the 50th anniversary event of the Texas Family Law Advanced Family Law Seminar. This is the biggest continuing legal education in the country. And every year, there were 1,700 attendees this time. A huge event in that we have, for instance, 10 family law courts in Harris County. They all close for the entire week. They close for the entire week because the judges and the attorneys are all there at that seminar. And Montgomery County doesn't entirely close, but they work very fluidly with the attorneys because they know anybody who does a whole lot of family law probably going to be in San Antonio the first week in August. So we learn a lot of things at the seminar. We look at updates in case law. We look at new legislation that's been passed. But this year, we had something I've never seen before. So I've been going to this seminar for 20 years. And this time they had a judicial survey where they asked judges and attorneys from all across Texas how they tended to rule in certain issues. You will hear a lot of times when people talk to a divorce attorney where maybe you go in and you meet with someone and what the attorney is telling you is different than the experience that your friend had, that your relative had, and you're probably wondering why. And I will tell you, so much of family law, first off, is very state-specific. Different states tend to have huge differences in how long it takes and what happens with children and what happens with property and whether there's alimony. It's like night and day. But even within Texas, where you have the exact same laws that we're dealing with, and we're even looking at the same case law, you still get different rulings from different courts. And I thought it was incredibly interesting just to see a lot of these really common questions be asked of judges all over Texas. And they asked them a lot of questions like, are you an urban judge? Are you a rural judge? Are you board certified in family law? Do you hear nothing but family law cases, or do you hear absolutely everything, and family law just makes up a little part of what you do? And then after they asked them those questions, they asked some of the biggest questions that people facing a judge in family law tend to ask, like, well, do you follow Texas guideline child support? How open are you to doing 50-50 possession schedule? How important is adultery? And all these questions were asked, and then we got back demographics of how likely different judges were to rule. And what we found out is exactly what most really seasoned divorce attorneys tell our clients all the time, which is you're going to get a different result depending on what judge you have. And the differences between those judges can be massive. So you might be thinking, if the difference that I get is going to depend on the judge that I have, why does it matter what lawyer I have? The number one reason that I think it's important, honestly, is I view my job as an attorney in two ways. Number one, absolutely, I am my client's advocate. I am there to tell the court their side of the story and make sure that the things that matter to them happen. But I would say that's only half my job, and I'm not even sure it's the most important part of my job. I think that as a divorce attorney, I need to meet with the client and help them understand what's likely to influence the court, what outcomes are really possible. Sometimes we have a client who really, really wants to do something, and I don't think that the judge is very likely to do it. So in those cases, I might tell my client, I will make that argument for you, and I will make that argument in the most persuasive way it can be made. But I want you to understand it's going to make your divorce take a lot longer. It's going to make your divorce cost a lot more. And at the end of the day, I don't think you're going to win this point. And if your attorney isn't giving you some idea of how likely you are to prevail on the issues that matter to you, I don't think they're doing a good job. I think that's why you come to us. It's like, honestly, when I go to the hairstylist, I don't follow the latest hairstyles. I want them to tell me what's current, what's going to look good. Well, your divorce is much more important, but sometimes clients need to be told this point is not going to matter to your judge, or I don't think you'll get this. And sometimes I think we can be very helpful in saying this other thing that you're not considering down the line, you might find out is really, really important. So, what are the issues that came out of the judicial survey? First one I want to talk to you about is 50-50. They had a whole lot of questions about a 50-50 possession schedule. This is a super hot button right now. A lot of people ask for it. I will tell you, I think anybody who is familiar with this podcast or my materials probably already knows I'm not a big fan of 50-50. I think that 50-50 possession schedules are overwhelmingly suggested by people who are trying to get out of paying child support. And my feeling is that it's not in the best interest of a child to spend half of their time with someone whose primary reason for wanting them is that they don't want to pay child support. Now, don't give me a ton of hate on that, because I also think 50-50 possession schedules are really bad for the great dads that I have out there. I think that when we have all these groups promoting a 50-50 possession schedule as the alternative, and the alternative that benefits men, I think you're setting up a world where if the woman wins, she gets custody. And if the man wins, he gets 50-50. Well, if I'm representing a dad who's an amazing parent, I don't want him to get 50-50. I want him to get custody. And that's one of my reasons why I don't usually recommend it. But another thing that I frequently tell people is most judges are not going to do it without agreement. So looking at a 50-50 possession schedule, what I usually have told my clients is it's easier to get custody than it is 50-50 if you don't have an agreement. And pretty much the only exception that I've historically seen to that is if the parties were already living a 50-50 schedule. If there was an agreement during temporary orders to do a 50-50, I think you've got a decent shot at getting it from the judge. But other than that, in my opinion, most of the time in front of the judges that I practice in front of, you're not going to be successful. And the judicial poll absolutely 100% bore that out. So first, all the judges, or 50% of the judges, 49.22, said they've seen a dramatic increase in the number of parents requesting a 50-50 possession schedule. But when they were asked, how often will you order a 50-50 possession schedule, when it's contested. So in other words, the parties don't agree. Somebody's asking for 50-50, or maybe they're both asking for custody. How often, Judge, do you say, I'm going to do a 50-50 possession schedule? And what the results showed is that 31% said absolutely never. Under no circumstances, if the parties didn't agree to a 50-50, they weren't going to do it. That means 1/3 of the judges in Texas, it doesn't matter if you've been doing a 50-50 for the last 3 years, which I've seen, parties separated for a long time and then they're getting orders and one party says, well, I know we've been doing this, but I don't want it to anymore. You're going to get 31% of the judges say that under no circumstances would they order it. And then you get an additional 37% of judges say, I do it less than 25% of the time. So a total there of 70%, yes, over 70% of judges say if the parties haven't agreed to it, I do it 25% of the time or less. And there are some judges on here that say they do it all the time, which I thought was interesting. You have 4 judges who say that they do it without the parties' agreement 76 to 100% of the time. I can tell you right now, I don't know who these 4 judges are, but they're not in Harris or Montgomery County. They're not in Liberty County. They're not in Fort Bend County. They're not in any of the counties that I've been to. And so the next question is, okay, well, 25% of the time or less, between 0 and 25%, judges will order 50-50 if the parties don't agree to it. How can I get them to do it? So here, the judges ranked in order what the most important factors that would lead them to order a 50-50 possession schedule. And number 1, you guessed it, just what I said, if the parties have already been doing it successfully. If the parties have a history when they get in front of the judge, and this is what they've been doing in the past, they've got a pretty good shot, or that is the most influential thing, to get a judge to order it to continue with the other party not in agreement. So the next most important factor was a history of family violence. Wow, I'm kind of like, how did the judges come up with that one? So I know a lot of judges, they're friends. I have friends that are, and I'm kind of going to ask them, where did this come from in there? But these are, I'm guessing that it's actually a factor leading them to deny 50-50, because the question asked was exactly, rank the importance of these 10 factors in your decision to grant a 50-50 schedule. And then the judges, it was an electronic survey, so they got to drag and drop what was most important to them. And so I am guessing that those judges that said a history of family violence, that's super important in my decision. I'm guessing that they're saying that that nixes it, that if there's a history of family violence, you're not getting a 50-50. Don't come at me asking for time with your kid if you've been beating your spouse or if you've been beating your kids. Kind of makes sense to me. And so I'm assuming that that's where that was coming from. So the next most influential factor is the ability of the parties to work together. So I will say, I get that. I do. I'm not a big proponent of 50-50, but there are times I support it. I do think it's a great idea when the parents live close together, when they get along, they can work together cooperatively. In my experience, if the parties can work together cooperatively, we're not having a final trial. So 88% of cases settle before a final trial. They settle at mediation. They settle through an informal settlement process. Somebody comes in and says, hey, this is what we want, and we write it up. So you're only talking about 12% going to a final trial. So if they're at a final trial, in my view, they probably do not have a history of being able to get along and cooperate and work together. So this question, the way it was phrased, it asks, rank the importance to grant a 50-50 schedule. A lot of people don't realize this, but judges don't have to let you do what it is you've agreed to do. And in fact, one of the questions that's in here is if the parties agree on it, how often are you letting them do their parenting schedule? And I will see if I can't find that issue, but I was surprised at how many of them said that there was a significant amount of time when they wouldn't agree to it. So I have been doing this a really, really long time. And I will tell you that that used to be a huge concern. I remember we had this judge in Harris County would not allow a child to fly on an airplane without a parent accompanying them. And it didn't matter. The parents could talk all day long about how the kid had flown back and forth, how they'd been doing it, how they could do unaccompanied minor. That judge wasn't granting it. I think she had an age she would, and I think it was like 15, 16 years old. And we had to worry. People would come to us and say, this is what we want to put in. And we'd be like, all right, let's think of the evidence that we can put on for the judge. And our clients would be like, what do you mean evidence? We both want this. Judge still has to approve it. Now, a few years ago, I think it's been about 10 years now, we got a huge gift from the appellate court and the legislature, where they said if you have a mediated settlement agreement, the judge can't overrule that. And so my clients, if they have an agreement, they want to do something, and I'm concerned that the judge won't agree to it, we're going to go and we're going to do a mediation. And it might be an incredibly friendly mediation where we all sit down at the table and say, mediator, is that I understand this is what y'all want to do. Is that right? Yes, that's right. And we come out with a mediated settlement agreement and that order gets in. So anyhow, issues that influence a judge's decision to grant or not grant 50-50. The third issue was the ability of the parties to work together. The fourth most common issue is the distance between the two homes. And remember where I said if you live together, I have seen this a lot where the judges, the most common geographic restriction that we used to see all the time would be, I practice primarily in Harris and Montgomery County, and it would be Harris and contiguous counties, meaning Harris and any county that touches Harris County. Or in Montgomery, we might say Montgomery County and any county that touches Montgomery County. Well, that is a huge, massive area. Well, if you're wanting your judge to accept a 50-50 schedule, you probably, judges like to see a restriction to the same school district. In other words, the parents have to both agree that they're not going outside Klein ISD. They're both going to live within Conroe ISD. They want to see them very, very close together. And then the factors that we have after that, we've got history of parental involvement before filing for divorce. The parties' work schedule, the desires of the child, the age of the child, the financial conditions of the parties, the medical needs of the child, and other people that get to see the child when they're with one of their parents. So in other words, aunts, uncles, siblings. A lot of families, they might have a sibling that's a child of mom's, but not a child of dad's, or vice versa. And the judges might take into effect what they want to do with that. So I thought that was very important for us to understand. How likely are we to get them, and what is it that you need to show the judge to be ordered to get it? Now, the next question that I thought was a great question for them to be asking about 50-50 possession schedule is, hey, judge, when you order a 50-50 possession schedule, is there child support? So if you'll remember what I said earlier is that the number one reason I'm not a big fan of it is because most of the time I'll see it as one of the parties trying to get out of child support. And I will tell you, I've had a lot of parents be just that blunt about it. They sit down and say, I want a 50-50 because I'm not going to pay. I'm not going to pay child support. I don't want that to happen. So, very important thing for people to recognize here is the judges across the state of Texas, when you order a 50-50 possession schedule, and these are actual results, how often does neither party pay child support? 17% of the time. So, in other words, 83% of the time, if you've got a 50-50 possession schedule, there's still going to be child support. And in my view, this is why you don't see more 50-50 possession schedules, because I've been involved in many, many cases where we explain to somebody, well, we might go for a 50-50. That's something that the other side seems open to, but your judge is still going to order child support. And then it's like, well, never mind. I don't want that then. So most of the time, you're still going to see that. So the 51% was the highest number by a margin. Usually what they're going to do is they're going to calculate if mom were to pay dad child support, how much would it be? And if dad were to pay mom child support, how much would it be? And then you take the larger number and subtract the smaller number. So you've got 51% of the judges in Texas saying that's how they're going to figure out child support in a 50-50 case. And that's been overwhelmingly my experience, where the parties agree on a 50-50 or where they've got a history of it. Maybe the only issue we're asking the judge to rule on is child support. Well, this is what I have seen happening. This is my judges. So you get 20% of the judges are going to do a very, very complicated chart. They're going to put all the list of the kids' expenses, and mom's going to be ordered to pay for some of them, and dad's going to be ordered to pay for some of them. So there's no legislative guidance on this at all. And that's why you get kind of a hodgepodge of how you're going to get who's going to pay how much child support in a situation where you have a 50-50 possession schedule. On my last podcast, I interviewed Dr. Jim Zettel about child custody evaluations. And one of the questions that I really thought was elucidating the most is asking the judges, how much do you think a child custody evaluation weighs in your final decision? And here we saw a huge difference between judges in the city and urban and rural judges. So overall, 62% of the judges said it was significant, that it had a very significant impact on their decision. 29% said it weighed in, but slightly. So to me, you've got 71% of judges saying slightly or significantly that child custody evaluation is really going to make a difference. But here's where, to me, it gets really interesting. And that is because urban judges, rural judges, 70% said it was significant. But you get judges in the city, and I believe Conroe is going to count as urban here too. Judges in the city, they're going to say only 53% of them say it's significant. And 39% says it slightly influences them. So you might wonder, why is there a difference? And my guess here is because some of the bigger cities, like Dallas and Houston, have court agencies called DRO, the Domestic Relations Office. And they will do a child custody evaluation. And they will do it much cheaper and much faster. And I will tell you, I have seen some child custody evaluations come out of the Domestic Relations Office. And I think we've got some great people there. I'm not wanting to malign them, but they do put significantly less time into creating them than the ones done by privately hired people. And My opinion here, I could be wrong, is that that's why you're seeing the judges in the urban areas don't give them quite as much weight because they spend less time with the individual parties. They're done more quickly. They are a little less in depth just because they're trying to make that as a resource available to people who don't have the ability to pay. One thing I thought was very interesting, though, is that lawyers, so they also asked a lot of these questions to attorneys. And I think in a lot of areas, we were pretty darn good at predicting what the judges would do. But there were some areas that there was a significant difference. And this is one of them. So 22% of the lawyers that were asked how much it mattered said the judge is just going to do whatever it says. In other words, it's 100% of the weight. It doesn't matter what anyone else says. The judge is going to look at that child custody evaluation, and he's just going to do what it says. So that's 22% of the attorneys and 2% of the judges. So I do think that judges listen to the testimony. In my own experience, I've seen those custody evaluations have a pretty heavy weight. I tend to use a private evaluator, and usually I see the judges agree. Now, there's other evidence that goes into it too. But if you're thinking about it, if you're talking with your attorney about this and wondering how much difference does it make, it can make quite a bit. So I mentioned earlier that the judges had indicated that sometimes they would refuse to enter an order that the parties had agreed on. And I said I was surprised because we know a workaround around that. Well, I will tell you, looking here, 68% of the judges said they rarely will refuse to accept what the parties agree on. 23% of them said never, that if the parties agree, they're going to sign it. So you have just 7.5% said occasionally, and one lone judge out there in the state of Texas says that he or she often will not enter an agreement that the parties have reached. So I don't think that judge is in my county, but I could be wrong. So the next thing that I wanted to talk about is child support. So this is an issue that we almost never go to trial on. And that is because when both sides have experienced family law attorneys, we tell them, look, this is guideline child support, and this is what the court is going to order. And almost always, in my experience, they do that. They very rarely order anything other than guideline. And so most of the time, the parties eventually agree to it. Sometimes you have someone, I'm not going to pay that much, I'm not going to pay that much, I'm not going to pay that much. And then if the other party just hangs tough, I'm not giving in because this is what's going to happen in court. Almost always, they're right. That's what's going to happen in court. So asking the judge, in what % of the cases do you order guideline child support? 76 to 100% of the time was the overwhelming response of the judge. 82.5% of the judges said either 76 to 100% of the time they're just following the guidelines. Now, one thing that I thought was interesting is they also said that they don't get asked to do anything other than guideline child support very often. And when judges keep saying they don't get asked, well, sometimes they don't get asked because we've been swatted down enough times. We know what's going to happen. Why are we going to go back and ask? But on the other hand, if you're having a full-blown trial anyway, because there's another issue that nobody can agree to, well, might be worthwhile to ask. Thought that was pretty interesting. But if your attorney's telling you this is guideline and this is what you're going to pay, well, 82.5% of the judges in Texas would agree. So the other issue that we don't try that often because I tell people that it's not likely that you're going to get a different order is a geographic restriction. So geographic restriction is, can I take the children far away from where they live now? So almost all orders, in my experience, are going to have a geographic restriction of some kind or another. As I said, sometimes it might be to a school district or to a county or, to an area around the county. But almost every order involving children is going to have a geographic restriction. So one of the questions that were asked of the judges is, how often do you modify or remove a geographic restriction? First, at temporary orders. And the answer here, 76% of the judges, less than 25% of the time. So 0 to 25%, almost all of them. Getting the court to allow you to move or to prevent somebody from moving at a temporary orders hearing, you're almost never successful. So you have 84% of the judges saying they won't order, lift a geo or impose a geo in temporary orders. How's that change up on final? Not a whole lot. You still have 75.5% of judges saying they usually institute a geo restriction unless the party can show it's not appropriate. And I can tell you from my experience, it takes quite a lot to convince the judges that a geographic restriction is not appropriate. So what's the takeaway from all this? You've got 100 pages of questions to attorneys and to judges about what the likely result is. So the one area that I saw attorneys being really bad at predicting what the judge said is adultery. So most family law attorneys, most divorce attorneys, people come in, clients, and I understand you feel very violated. Your trust has been ruptured. The spouse has committed adultery, and it's really important. And they want to spend a lot of time at trial proving to the judge that the spouse committed adultery. And I was one of the overwhelming majority of attorneys that really kind of tried to talk people out of that in most cases. We might mention it, but in my experience, it does not make any difference. The judges are not impressed by adultery. They hear about it too often. It doesn't tend to affect who gets the children, and it doesn't have very much effect on property division. Now, if you've got one party's a stay-at-home mom and the other party earns a lot of money, or a stay-at-home parent, I should say, and the other party earns a lot of money, and they go out and they found somebody 30 years younger, and now they want to kick the mother of their children to the side. In those cases, I do see it makes some difference, but that's about the only time. So I was a little shocked at what I read in this judicial poll. According to the judicial poll here, most attorneys would agree with me. 99% of rural attorneys and 95% of urban attorneys will say that proving adultery makes very little or not at all difference in how a judge divides property. But what surprised me is that 31% of the judges say it matters a whole lot. That one caught me by surprise. And it's definitely got me wondering, maybe I ought to push that a little harder when I have a contested trial. So they did break it down by rural and urban, but there's not that much of a difference. 27% of urban judges just also said that it makes very much difference if adultery was committed in deciding whether or not to divide the property in half or not, or give one party more. So what's the big takeaway from all of these hundreds of pages, just 100 pages, of opinions of judges on what they do and what attorneys think that they do. Overwhelmingly, I think it confirmed my view of what judges were likely to do. But what I'm wondering is how much difference it's going to make to the judges, because judges are very human people and they really, really want to do what's right. And my guess is if you have a judge doing something and then that judge learns that, oh, almost all the other judges that hear divorce cases do it differently and disagree with you. I would bet that most of the judges, they might still, and don't get me wrong, there are definitely judges that are going to say, I don't care. I don't care if I'm the only judge in Texas doing it this way. I think it's the right way. But I think most of them might stop and reevaluate what they've been doing. And I'm very curious to see if some of these areas I start seeing influence my judges. So I'm mostly Harris, Fort Bend, Montgomery, the greater Houston area. My judges are super active in this. They're giving the presentations at this seminar. They were sitting in that great big room with me. I spoke with a lot of them. They heard all this presentation. I will tell you, if anybody is likely to be influenced by what they're reading here, it's going to be the judges in our area, because they really care about getting the law right and they're paying attention. So I guess we'll see.